What's up, guys? This is Manoj Poptani. I welcome you all on behalf of the Edupedia world. So, guys, by now we have almost covered 5 of the presentations for the Foreign Exchange Management Tech 1999, and I just hope that you guys are revising your topics. Perfect, guys. Let's head start with this particular presentation. Fasten on your seatbelts. We are about to take off with the first topic of the day, and that will be the procedure for adjudication. So, the same thing is being covered under section 16 of the Foreign Exchange Management Act 1999. What is the procedure for adjudication in this particular case? So, first of all, that will be the purpose of appointment and duties. Adjudicating authority. Okay. So, adjudication can only be done, guys, by the adjudicating authority. Adjudicating authority is the only authority which is going to go for this adjudication. Okay. What is the purpose of their appointment and what are their duties? So let's understand that, because with any kind of a procedure will come later on, but the purpose of their appointment and their duties should come first and the foremost thing. So the adjudicating authority shall be appointed by central government by issuing a notification in the official gazette. That's how they are appointed. So they'll be appointed by central government by issuing a notification in official gazette. Official gazette is a kind of a document, a kind of a newspaper look-alike kind of a document, which is in which usually notifications are being provided wherever and whenever some kind of notifications are being provided by central government, state government. Official gazette is an official document wherein the same notification gets published. That's about official gazette. So the adjudicating authority shall be appointed by central government by issuing a notification in the official gazette. The adjudicating authority is appointed to adjudicate and impose the penalties. So that's their purpose. Their purpose of existence will be to adjudicate and impose the penalties. Next will be that the adjudicating authority shall endeavor to dispose of the complaint within 1 year. That's their endeavor. What kind of endeavor they should have? So they should require to have this kind of endeavor wherein wish to dispose of all the complaints. Okay, within that 1 year. From the time they actually arrive at the table and desk of the adjudicating authority. So their endeavor should be to dispose of that complaint within 1 year. Next, before making any of the judgment, okay, this is again a kind of a thing which is a very noble thing and which is actually a required thing which needs to be done. So that's about their appointment, that's about their purpose, and that's about their duties. I hope you guys got the clear picture. Perfect, guys. Let's move with the second aspect, and that will be the cognizance of offenses. So guys, what does cognizance basically mean? First of all, get that. So cognizance basically mean getting something into your attention. That's about cognizance of offenses, getting that offense into your consideration, your attention. Section 16 basically simply says that the adjudicating authority shall not take cognizance of any of the contravention under FEMA except upon a complaint in writing made by any officer authorized by central government. So, if in case you don't get a complaint in writing which is being made by any of the officer authorized by central government, then in that case, adjudicating authority shall not accept or give any attention towards that contravention under FEMA. So, it has to be taken care of in that way. Adjudicating authority shall not take cognizance of any of the contravention unless that has been made with the help of complaint in writing made by an officer authorized by the central government. So that's the cognizance of offenses. Next will be the issue of show cause notice. So what do you think? What will be the purpose behind issuing of any of the show cause notices? Well, simple. Like in any of the department, whether it's be it income tax, be it sales tax, so the purpose of issue of show cause notice is always the same. That is to provide a reasonable opportunity to the accused to show cause as to why an inquiry should not be held against him. That's a time which department usually provides to that accused to show cause as to why the inquiry should not be held against him. And if in case he replies within the stipulated time, then that's well and good, and the case can be easily cleared out in that case, and further actions can be taken off. But if in case the time allowed should be at least 10 days before giving further reply. So accused shall be given at least 10 days time for giving a reply. So that's the time allowed. And if in case the accused doesn't give the proper reply within those 10 days, then in that case the prosecution can take up any other further steps. against that particular accused in that case. So that is something about show cause notice. So the procedure for adjudication is being covered under section 16. Their purpose, their appointment, their duties has been like told to you. Appointment by CG and by issuing the notification on official gazette. They are appointed to adjudicate and impose penalties. Their endeavor to be dispose of each and every kind of complaint within the 1 year of its coming into their desk, and they should provide a reasonable opportunity of being heard before delivering the final verdict to that accused person. Cognizance of offences. So they the adjudicating authority shall not take cognizance of any of the contravention under FEMA except upon a complaint in writing made by any of the officer authorized by central government, and in case of issue of show cause notice. So the purpose is to give an opportunity, a proper opportunity to the accused to show cause as to why an inquiry should not be held against him. Time allowed, minimum 10 days to give the reply. Perfect. I hope you guys got the complete clarity with respect to these three different subpoints as in relation to procedure of adjudication. So that still continues, second slide as well. So it's going to continue. So here it is. Now, what will be the procedure for holding inquiry? Okay, so adjudicating authority has been like appointed by CG by in order to like basically adjudicate and impose the penalty. So what should be the procedure of holding an inquiry in that particular case? So first of all, that adjudicating authority shall consider the reply which has been made by the accused person. So accused person must have made the reply within those 10 days. So they shall first consider that reply which has been made by the accused person. Next, they shall fix the date of hearing if it is of the opinion that an inquiry should be held. So before that, they shall fix a date of hearing in that case, if in case they feel like that an inquiry should be held. Okay, so date should be fixed. Next, hearing shall be held accordingly on that particular date, and a few provisions shall be applied during that particular hearing. Number one, that accused may either appear in person or he or she may take the assistance of legal practitioner or a chartered accountant. So that's something that that is kind of a right which has been like provided to the accused person. He may appear in person or he may take up some of the assistance of any of the legal practitioner or a chartered accountant. Number one. Second, adjudicating authority shall explain to the accused person the alleged contravention. So because it's clearly evident that that accused might not be having some good knowledge about the act, so it is the responsibility and endeavor of adjudicating authority to explain to the accused person the kind of alleged contravention which has been made against him or her. Number three, accused shall be given a reasonable opportunity to produce such documents or evidences as he may consider relevant to the inquiry. So he should be given a chance wherein he can represent some of the documents or evidences which he thinks and consider that these are relevant to the inquiry. Next, the hearing may be adjourned from time to time. That's on the discretion of the bench for adjudicating authority. Next, the adjudicating authority may summon and enforce attendance of any person to give evidence or to produce any document. So by summon or enforce attendance, I simply mean that they may send the police officers into your home. That is basically the summons. So that are the official departmental heads which are basically being like sent in order to enforce your attendance, to provide some of the evidences or to produce any of the documents. So they may summon or enforce the attendance of any of the person to give evidences or to produce any of the document. Lastly, adjudicating authority may also proceed with ex parte. So by ex parte, it simply means that supposedly you were called upon, okay, and somehow you were not able to be present during that particular time. Okay, so the case may fall in favor of the court. In that case, the person who has like alleged you up, so that would be like state versus you. So that may go into the favor of state. Why? Because you were just not present during that hearing. So the adjudicating authority has the power to proceed with ex parte. So ex parte is given and waiving off the result in favor of one person due to absence of another. So that's ex parte. So that is the procedure for holding the inquiry. I hope you guys got the complete clarity as to what is the procedure for holding the inquiry. Perfect, guys. Let's move to the next topic for the same thing, that is the procedure for adjudication. So that's going on currently as well. So now comes into the picture, that is order part. So guys, order levying the penalty. Now it has been proved that if in case that AA, that is adjudicating authority, is satisfied that contravention of the act has been committed, then in that case it shall impose penalty and specify the nature of contravention which has been committed along with the reasons for that particular decision. So that will be the case. So order levying the penalty will be made once the adjudicating authority is satisfied that the contravention of the act has been committed. Accordingly, it shall impose the penalty and specify the nature of the contravention which has been committed by the accused person along with the reasons of their decision. So that's going to be the order for levying penalty. Next will be the imprisonment. Okay, with order definitely will come some amount which is required to be paid as penalty, and if in case the penalty is not paid, obviously the government and RBI won't have any other option and they'll resort to the imprisonment of the accused person. So if in case the accused person doesn't pay the penalty, then what's going to happen? Imprisonment for non-payment of penalty. The same is covered under section 14. Number 1, the penalty must be paid within a period of 90 days. Okay, that's the clear thing. Imprisonment will happen if in case the penalty has not been paid within the 90 days and supposedly the person was not able to provide this penalty amount within 90 days. Then if default is made in payment of penalty, then the accused shall be liable to civil imprisonment, and the term for that imprisonment shall be up to 3 years if the penalty amount exceeds rupees 1 crore or up to 6 months in any other case. So that simply means if in case the amount does not exceed rupees 1 crore, so imprisonment will be up to 6 months, and if in case the penalty amount exceeds rupees 1 crore, so in that particular case it will be 3 years, up to 3 years. So that's the term of imprisonment. And what if supposedly I'll ask you this question. So what if in case the accused person willfully wishes to now pay the penalty once he has heard about this order of imprisonment? What's going to happen? So don't you think that if in case he pays that particular amount of penalty, so the government should release him from that imprisonment, obviously? So the defaulter shall be released if in case the penalty is paid after imprisonment. So imprisonment gets started and he pays off the debt, so he will release accordingly. So because only for the sake of saving a person from imprisonment, that person usually pays the penalty on time, and if in case he doesn't pay the penalty on time, definitely that will be most welcome if in case he pays during that imprisonment as well. So the defaulter shall be released if penalty is paid after imprisonment. So perfect, guys. I hope that's absolutely clear to you. So now let's move to our next topic, the last topic of this presentation, and that will be the appeal. So now procedure for adjudication is being done. You just got to know that what will happen if in case adjudicating authority basically declares, offers the verdict in favor or against that accused person. So now supposedly the adjudicating authority has offered their verdict and that went against that person, that accused. So don't you think that will be undue hardship for that particular person if no chance or opportunity of making appeal to a higher level authority is being allowed to that person? Absolutely, that will be an undue hardship for him or her. So the appeal to SD appeals, that is going to happen under section 17 if in case that same thing which is available to the accused person once the adjudicating authority provides their verdict. So the appeal to SD appeals may be made against the order of adjudicating authority if the adjudicating authority is assistant director of enforcement or deputy director of enforcement. So, and that particular appeal shall be filed within 45 days. So that's the important thing to be noted. So the time limit for filing that appeal is 45 days after the order of adjudicating authority. Now that is one part. The another part and aspect of this story is appeal to appellate tribunal, that is AT. So section 19 offers you the briefing relating to the same. So if in case you don't get satisfied with the kind of response that you got from SD appeals as well, okay, and you were just not satisfied with the kind of response and verdict you received from the adjudicating authority. So in that particular case, that accused person can still move towards while like filing appeal to appellate tribunal as well. So appeal to appellate tribunal may be made against the order of SD appeals. Appeal to AT may be made against the order of adjudicating authority if in case the adjudicating authority is a person other than Assistant Director of Enforcement or Deputy Director of Enforcement. Now, let's just correlate this particular point with the point which is being mentioned, appeal to SD appeals. So, now you can get correlation with the fact that why it was written if adjudicating authority is Assistant Director of Enforcement or Deputy Director of Enforcement. Why? Because if in case he is that person, then you can provide and go for the option of making appeal to SD appeals if the same adjudicating authority is Assistant Director of Enforcement or Deputy Director of Enforcement. But if in case that adjudicating authority is a person other than these two, maybe higher than them, so in that case you can directly go for an option of appealing to appellate tribunal as well. So appeal to appellate tribunal may be made against the order of adjudicating authority if adjudicating authority is other than Assistant Director of Enforcement or Deputy Director of Enforcement. The time limit for making the appeal will remain the same, so the appeal shall be filed within 45 days. The penalty determined by adjudicating authority and SD appeals shall be deposited. First of all, while making any kind of appeal to appellate tribunal, so it is being taken care of that first of all you need to submit your penalty, okay, and then file and fight your case accordingly later on. But first of all, that penalty amount needs to be deposited. So that will be taken care of by the government and tribunal itself. And lastly, however, if in case appellate tribunal has a discretion to dispense off with the payment of penalty as well, if it is satisfied that the deposit of penalty would cause undue hardship of the accused person. Now, this basically relates to a situation wherein appellate tribunal is believing of the fact that the person who has been termed as the accused person over here is just not capable of paying that penalty amount. Maybe that penalty amount is so huge for him to pay, or maybe that amount is still small, but the overall income of that accused person is just not feasible, or like he's just not capable enough to pay that penalty amount. So don't you think in that particular case that will be like very much undue hardship on that particular person? Absolutely, it will be. The appellate tribunal has the discretion. So if in case they want to, they wish to, yes they can. So they can dispense off with the payment of penalty if they are satisfied that the deposit of penalty would cause the undue hardship on the accused person. So that was all about appeal to appellate tribunal under section 19. So in this particular slide I did discuss with you the topics relating to appeal to SD appeals section 17 and appeal to appellate tribunal section 19. So I just hope that you guys got the complete clarity about the same thing. So remember that the appeal shall be filed in both the cases within 45 days. Perfect guys, with this I'll be concluding my video with a dose of motivation, and that will be your current conditions do not reflect your ultimate potential. Anthony Robbins quoted this quote. Perfect guys, with this I'll be concluding with a thank you on behalf of the Edupedia world. Keep interacting via questions, queries and YouTube comment boxes. We love to help you out with any of your queries and grievances. Stay connected, that will help us in understanding your needs way better.